Commissioner at the Alberta Human Rights Commission. So, but just before we start, I just, in the interest of full transparency and disclosure, I am not Indigenous. I'm actually an old white man who apparently has been asked to speak here because I know something about human rights. And the reason I say that is because, as we know and as we've learned, you know, where people come from will impact their perspective on things and how they engage with the law and so forth. And I've had the good fortune in over the past few years since the TRC and a little bit before, really starting to learn about Indigenous traditions and cultures and history and treaties and that sort of thing. And you know, in different ways I recognize how my own identity and tradition is different and explore, well, how does that, what difference does that make in terms of how I see the law and human rights and so forth. So just one quick example is I've come to learn that within the Indigenous community, elders play an important role. They're knowledge keepers, they are wise, they have a responsibility to ensure balance and harmony within a community and to make sure decisions that are taken, as I understand it, have regard to generations, in fact 6 generations I think to come. In my cultural traditions, elders, at least white men, are grumpy, cynical types who have no care about the community. In fact, we try to create anger and dissension to keep our privilege. And not only don't we care about 6 generations, we hardly care about the next generation. So I've had to come to terms with that, and I do try to keep that in mind. But I say that obviously in humor, but also there is an important point, and that is, I think when we talk about human rights, when we talk about the law, when we're going to talk about jurisdiction, we have to understand that you know, law has an important role both in terms of aspirations and creating a better communities, a better world, but also at the same time, you know, it presents limits. And so I think as we have this discussion about jurisdiction, we have to understand those limits and the potentials, and that this is really about strategy for communities who have traditionally been disadvantaged, have suffered disadvantage, and have not necessarily been able to express their aspirations in an equal way, to really think strategically about why you would use human rights in particular circumstances. So I'm going to turn it over to...
I'm privileged to work with the Canadian Human Rights Commission and to work with our provincial and territorial partners. My name is Sherry. I'm pleased to be here on the traditional territories of the Treaty 7 peoples. I hearken from Treaty 1 territory myself. I'm a proud member of the Sandy Bay First Nation, which is a Treaty 1 First Nation in Manitoba. I've worked with the Canadian Human Rights Commission for 29 years in a variety of roles, starting off as an investigator many years ago, and currently working as the Director of Complaints Coordination and Equal Access with a lot of my colleagues from Ottawa. But I had the privilege of working for a number of years with what we called our National Aboriginal Initiative, which had as its objective to reach out and build relations with First Nations, Métis, and Inuit stakeholders across the country. And I have to say it was a tremendous learning experience for a number a number of years learning about Indigenous legal traditions and laws and different concepts of human rights. But what we're here to speak about is the federal and provincial human rights acts and the points of time at which you might find yourself in a position that you might want to call either the Alberta Human Rights Commission or the Federal Human Rights Commission. So let me just kind of launch into some of the questions that you'll have seen in the agenda for this event. What should trigger someone to engage with the Provincial and Federal Human Rights Commission? Do you have any experience or cases that have come in related to health and discrimination? Do you see gaps between the provincial and federal commissions? And what value does the commission add in addressing these issues? So before we get into the questions, Michael and I thought that it might be a good idea to give a little bit of a background, or a primer, on what's covered under the federal and provincial human rights statutes and how these things work. So effectively, we're going to take a few minutes to talk about the human rights framework. And Michael will be asking you to make a few comments in regard to the overall human rights framework. Then we'll get into a little piece on understanding jurisdiction, and I'll be taking that on if you have no objection, Michael. And then we'll both kind of do a tag team on what's protected under the Alberta Human Rights Act and the Canadian Human Rights Act. So, general comments to start.
So generally, the human rights, and Renee talked about it this morning, human rights sort of exist on a number of levels, internationally, within states or territories, and generally when we talk about human rights within Canada, or human rights commissions, human rights legislation, we're really talking about anti-discrimination legislation. So what the rights that are enshrined and says, well, you cannot be discriminated against because of X, Y, or Z within a particular domain, for example, employment, housing, or services.
So as Michael was saying, and as Renee had mentioned earlier, we start off with kind of the international instruments like the UN Declaration of Human Rights, setting the framework for how domestically we have integrated human rights protection into our laws and practices. And so, as you'll note, we're separated into federal and provincial jurisdiction. There are other human rights protections like the Charter of Rights and Freedoms, and of course there's constitutional rights that are protected. Under federal jurisdiction, the Federal Human Rights Act, it creates two bodies, the Canadian Human Rights Commission and the Canadian Human Rights Tribunal. They're independent of each other and of government, and the Commission's role is primarily a screening role in terms of complaints. It should, in some circumstances, we will refer a complaint to the tribunal, which is, as I say, an independent agency, and they will hold a full hearing into complaints that are referred to it. And Michael will be speaking about provincial jurisdiction, because there are some in Alberta, it's set up a little bit differently. We also know that First Nations, Métis, and Inuit governments also have a role in human rights protection, depending upon their circumstances and how they want to protect the rights of their citizens. So let me get into a little bit about, does the federal or provincial Human Rights Act apply? So effectively, federal jurisdiction kicks in certain circumstances. Everything else tends to be provincially regulated. So the federal jurisdiction extends to federal government departments, agencies, and crown corporations. Things that are federally regulated like chartered banks, airlines, television and radio stations, some mining companies, interprovincial communications, telephone and interprovincial transportation companies, and First Nations government and some First Nations organizations. But not everything that occurs on a First Nation territory or on a reserve is federally regulated. And so there's been a lot of court and legal jurisprudence that's grown up around when the federal or provincial Human Rights Act applies. And probably the most conclusive case where this was looked at was the NITWA case, which dealt with a Child and Family Services Agency operating out of BC that provided services specifically to First Nations communities. But because of the nature of operations, because of what NITWA, Child and Family Services Agency, did, the Supreme Court found them to be within provincial jurisdiction, not federal, even though everything that they did was on reserve. So in terms of the test that the Supreme Court used, they said that when you're trying to determine jurisdiction, you need to look first at the nature, operations, and habitual activities of an organization. If these tend to be provincial in nature, if they're things like child and family services, or in many circumstances health services, or within the province bus company, or a shoe manufacturer, or a retail organization, it's likely to be provincial. Most of the things that are federal will be First Nations governments, and things that are how do I say, at the core of what the First Nation does. So just to give a couple of quick examples, organizations that have been found by the courts to be subject to federal regulation include band councils, a nursing station that was under the control of a band's finance department, a tribal council whose purpose was to promote the objectives of member First Nations, and a program and services department of a self-governing First Nation. Organizations that have been deemed to be under provincial regulation include, as I had mentioned, a First Nation Child and Family Services Agency that provided services to First Nations members, a treaty association that supports the economic development, education, and culture of member First Nations, an on-reserve shoe factory owned by Indigenous people, an on-reserve ambulance service that assists both First Nation and non-First Nation patients, an on-reserve Ontario Works office that issued status cards one day a week, an on-reserve addictions treatment center that was created specifically for Indigenous clients, and a separate and distinct office established by a First Nation to negotiate contracts with Manitoba Hydro. So these are case examples drawn directly from court decisions. So in essence, jurisdiction is not always clear. Sometimes the courts don't even get it right, and things need to go to the Supreme Court for clarification. But the one thing that I would say is, if in doubt, contact one of the commissions. We can help. And with that, over to my colleague, Alberta Human Rights Commission.
All right, so now that everyone's clear about jurisdiction, actually Sherry said sometimes the courts don't get it right and then it goes to the Supreme Court. There's a saying that goes something like this, that judges aren't appointed, judges on the Supreme Court are not always right. They're always right because they're on the Supreme Court. So yes, this is how lawyers keep their monopoly by keeping people confused. But I think that, see, that's my cynical old white guy speaking. I think Sherry's point is, I mean, it's important because if Indigenous folks or non-Indigenous folks are dealing with matters involving First Nations, Métis or Inuit, whether from the perspective of being employed or seeking services or housing, or as a service provider or an employer or a landlord, from both sides, you need to have an understanding of where the responsibilities and obligations, rights lie. So, as things develop, there are more and more cases where the examples and precedents help along the way. So I'm just going to talk a little bit about the Alberta Commission. And Sherry was talking about the Federal Commission has, there's the Federal Human Rights Commission and the Federal Canada Human Rights Tribunal. In Alberta, we're a bit different. So the Alberta Commission has sort of three parts. One is called the Commission of the Director's Office. So that part is the unit that provides information. We have a call center that provides information free of charge on a confidential basis. We receive complaints, and we receive about 1,200 to 1,400 complaints a year and accept about 800 or 900 complaints. Those we provide mediation services to try to resolve them, and if they don't settle, they may go through an investigation, and ultimately the director, who's independent from me, who's the head of the tribunal, will make a decision whether or not the case has merit and should be, if it's not settled, proceed to a tribunal hearing. The second unit, of course, is the tribunal, which is similar to a court, although less formal, having expertise. The members have expertise in human rights, and we will hold hearings. We also do mediation. And then the third unit is what we call our Communication, Education, Engagement Unit, again, which is pretty unique amongst commissions across Canada because we administer the Human Rights Multiculturalism Fund, which provides grants to communities and organizations, and we're proud to be sponsors of John Humphrey's and other organizations, including Indigenous organization, advocacy organizations. So that's really cool because we are able to work also on a systemic level to help communities build capacity for advocacy.
I wonder, Michael, so you've talked about the Alberta Human Rights Commission, and you've referenced what's in the Alberta Human Rights Act around employment, tenancy, goods, services, publication of notices, and membership in trade unions. I wonder whether you might want to share some thoughts with us on what is discrimination.
Sure. So discrimination is obviously being denied a service or employment, housing, suffering an adverse treatment because one of the prescribed grounds. So we sometimes speak of direct discrimination, which may mean no women allowed to apply for this job, or you need a driver's license for this job, so somebody like myself who's blind can't apply. That's direct, sorry, I shouldn't have used the driver's license. If you're blind, you can't apply. You can't be somebody who has epilepsy if you're going to work on a railway because of safety matters. So that's direct discrimination. It's saying one of the grounds, race, religion, disability, mental or physical disability, that you are not permitted to receive service or to be employed or rent a house or an apartment because of your disability. The other type of, because on a discriminatory ground. The other type of discrimination is something we sometimes called adverse effect or indirect discrimination, and that's where it's not direct discrimination, but the rule, which is neutral on its face, has an adverse impact on individuals. So for example, there was a case many years ago that I was involved in where it said that airline pilots had to be a certain height if they were going to be hired. And what some women and individuals of Asian Heritage argued is that they were disproportionately affected because on average they couldn't meet, or on average wouldn't meet those height restrictions. So there's an example of adverse effect. Or as I said before, if there's a job, something in the job ad that says you have to have a driver's license, I wouldn't be able to apply. The rule is neutral. There's nothing that says you can't be discriminated upon because you have a driver's license or not, but it has a disproportionate effect on individuals who are blind or don't have a visual acuity. And then what happens at that point, where if a person makes such a claim of discrimination, it then turns to the respondent, the employer or service provider, to say, well, look, this restriction, this discriminatory restriction that we have imposed, whether it's direct discrimination, you can't work on the railway if you have epilepsy, or indirect, you have to be this height if you want to fly an airplane, is what's called bona fide occupational requirement or bona fide occupational qualification, or it's that the rule is taken in good faith, number one, that it's connected to the endeavor or the service or the provision of service in some way that relates to safety or that sort of thing, and it cannot be accommodated without undue hardship. All right, so again, to use the job and a driver's license, I've had jobs where it required to have a driver's license. I haven't had to file a human rights complaint, but obviously there are ways to accommodate me. I can take a bus. I may be given some extra time to get somewhere. There may be, people, the company will pay a taxi rather than having me drive, or maybe I won't get assigned work that is in remote locations that is not accessible by public transportation. So the question often comes down in cases, is it undue hardship in order to, would it be undue hardship in order to address what's on its face, perhaps justifiable discrimination? And that's where many of the cases come down to.
Great, thank you. Okay, so, excuse me. We were going to go to an all play, like a situation where we throw out a question to the crowd to get your perspective on a particular situation. So let me just read it and we'll think about it, and then I'll ask for a show of hands on kind of a yes or no. Are you allowed to ask an employee to take out their body piercings or hide their tattoos during work shifts? So think about whether that could be a complaint of discrimination under the Alberta Human Rights Act or the Canadian Human Rights Act. But first, before I ask for a show of hands on yes or no on this, I see that there's a question.
Yes. I think I figured it out, but just to clarify if I'm wrong, I'm assuming there's limitations to everything that's kind of mentioned. Just use the driver's license bit. If you were to go for a class 1 job, truck driver job, and they were to say, well, it's not reasonable to accommodate if you can't drive a class 1, would that be appealable to the commission? Is that something, does that make sense?
Okay, so the question was about going for a class 1 driver's license. Are there limitations around when there might be a circumstance where, maybe a person would not, would be eligible to apply for a class 1 driver's license? What do you think, Michael?
Yes, I think that's true. I think it depends on the circumstances. I think oftentimes when we're talking about undue hardship in general, where the general rule has usually it's about safety issues or cost. And this is why undue hardship sometimes will fluctuate. If you're dealing with, can you accommodate somebody and it's a small enterprise with 1 or 2 employees versus a public service or a hospital, the answer could be quite different. And we see that sometimes when it comes to allegations of discrimination based on family status, where people work shift work, where the rules are that you have to work sort of 4 days on, 4 days off, sometimes nights, sometimes days, and perhaps you have one of the parents who is the primary caregiver says, well, I can't work at nights because I can't get childcare. And so there have been cases that have looked at whether the employer has an obligation to make accommodation. In other words, give the person a particular shift because they need to accommodate the daycare or childcare. And it really will depend on, amongst other things, if it's a 2-person employer, 2 staff members, it may be undue hardship. If you're talking about, a nursing staff in a large hospital, it may be more easier to do.
Thank you. Okay, so we have one more question, and then we're going to do our all play, and then I get to talk about the Canadian Human Rights Act for a little bit.
Hi, thanks for taking the question. I appreciate that. I was just going to ask, with Dr. Cindy Blackstock having, brought the case to the Human Rights Tribunal, basically making a case that Indigenous kids were getting funded less than non-Indigenous kids, and the federal government now being found to have discriminated. Now I think that, I don't know the number, I think it's $250 million that they've been ordered to pay. So now we're sitting on the fence waiting for Justin Trudeau to say he's either going to honor that $250 million payout, or settlement, I guess it would be, or whether or not he's going to appeal it. I guess my question is, what happens next? So if he decides to appeal it, does that stay in the arena of kind of the Human Rights Tribunal, or does that go on to something bigger, like the Supreme Court? I guess my question is, what are the next steps at that point?
Thank you so much. And perhaps because that case arises in federal jurisdiction, and in fact, one of the ones that I was going to mention, maybe I'll take that question now. Okay, so that was a very significant case brought by the First Nation Job and Family Caring Society. And I would have to say it was probably one of the first really big systemic cases in this area that we had seen. There's been others since, and I'll get to those. But your question is a good one. Now that, okay, so the case was looked at by the commission. It was referred to the tribunal. The tribunal heard many witnesses, saw lots of evidence. Both parties had their opportunity to provide their sides of the story. The tribunal came down with a decision that ruled that, yes, the federal government had discriminated against First Nations children. The tribunal did not, in the first instance, award a remedy, but they had, since the initial decision a couple of years ago, they've now come up with, I think, a series of 6 or 7 compliance orders that say, there has to be some action taken to remedy this situation. Most recently, was it just last week, they came out with the decision that essentially said the First Nations children who had been negatively affected by the child welfare system were due compensation. And and in terms of the amount of that compensation, it could be upwards of, well, I heard some media reporting that it could be in the area of a couple of $2 billion when you get right down to it, if every First Nations child affected by child welfare were compensated. There is after that compliance ruling by the tribunal, there is a 30-day period wherein either party can seek judicial review. So the federal government may choose to go to the federal court in order to seek judicial review of that tribunal decision. So we're waiting and seeing at this point. If they do not decide to go to judicial review, then the tribunal was not specific about how exactly that compensation is to be awarded. They remain seized of that decision, and the parties are supposed to take their guidance and figure out a process for deciding the compensation within a year after the tribunal decision. So we still have to wait to see how that's going to roll out and if the tribunal decision is going to be appealed. But it was a significant ruling in a very significant case. So this is kind of the purpose section of the Act, and while we are best known at the Commission for dealing with complaints of discrimination, we do have other mandates as well. We try to protect the public interest both by prevention of discrimination through development of learning tools, development of policies, some education work. So we call that kind of our promotion function, and then also there's protection, that is screening, assessment, and inevitably litigation of discrimination complaints before the tribunal. We also have a mandate under the Federal Employment Equity Act. So we look at representation of 4 designated groups, which include women, persons with disabilities, visible minorities, and Indigenous peoples in federal workplaces, to ensure that there's no undue barriers or obstacles to employment and retention. And we also have a new mandate under federal pay equity legislation and the Accessible Canada Act that seeks to eliminate barriers for persons with disabilities in federally regulated workplaces and areas of service provision. Like the Alberta Human Rights Act, for a person to file a complaint under the Canadian Human Rights Act, it needs to be in specific areas and based on specific grounds. So generally, services, employment, and including harassment and retaliation within the context of employment and services are things that are covered. And again, based on a number of grounds like race, color, age, sex, national ethnic origin, disability, family status, marital status, pardon, conviction. We have a couple of new ones over the last year, 2 years, that have been added to the Canadian Human Rights Act, and that includes gender identity or expression, and also genetic characteristics, which is really kind of interesting. And we've received one of our first complaints, actually in a First Nations context, where a person believes that they were discriminated against based on a genetic test. Kind of a new and evolving area. Given that genetic testing is becoming more and more prevalent. Okay, so one more little all play, and then I'm going to get into specific examples that pertain to the discussion today. So, all play. A restaurant will not seat you because you have a service animal. What ground of discrimination is being used against you? Who has an answer for me? What ground? Okay, this hand went up first.
Direct discrimination?
Direct discrimination. On what basis? When we were talking about those grounds of discrimination, like race or color or age or sex, what ground do you think is involved?
Disability.
I wish I had a prize, but I don't, I'm afraid. I'll give you a booklet later. Yes, direct discrimination based on disability. Okay. So, I'll just cover very, very briefly a little change to the Canadian Human Rights Act that happened about 10 years ago that led to some provisions in the Act that are specific to a First Nations context. Before 2008, there was a section of the Canadian Human Rights Act that said that nothing in this Act shall apply to any matter flowing from the Indian Act or the application of that Act. So, you know how Renee had mentioned earlier that human rights legislation has primacy over, it's kind of fundamental legislation that regulates a number of other areas? Absolutely true. But prior to 2008, the Indian Act was exempt, and anything flowing from the Indian Act was exempt. We didn't receive very many complaints from Indigenous peoples at that time because of that shield. In 2008, it was finally repealed after we had been calling for repeal for many years. And as a result, there was a couple of things that were put in the Federal Human Rights Act that might be pertinent for our discussion. One was a non-derogation clause that says that nothing in the Canadian Human Rights Act shall abrogate or derogate from existing Aboriginal or treaty rights. And another is an interpretive provision that says that essentially decision makers under the Canadian Human Rights Act need to give due regard to First Nation legal tradition and customary law, including the balancing of individual rights and interests with collective rights and interests, to the extent that they're consistent with the principle of gender equality. So this means that Indigenous legal traditions and cultural law need to be taken into account when you're looking at a human rights concern. So following that legislative change, the Canadian Human Rights Commission had struck a small team, I'd say, of people to do some targeted promotion to raise awareness of what this Federal Human Rights Act is all about. So we developed a number of learning guides, we did some youth engagement, developed a game around human rights, set up a web page, we were active on social media, appeared at conferences, and one of the guides that we worked on with Native Women's Association of Canada, Your Guide to Understanding the Canadian Human Rights Act, I have available today for anybody who's interested. It was one of the first guides that our commission did in plain language, and in fact it was so well received, both beyond First Nations audiences, that we've taken the same publication and made it general to everybody in Canada. So it's one of our most popular publications. But let me get to the really fun stuff that we wanted to cover today. Some examples of cases that have arisen in a federal context involving First Nations and health situations. Beetle versus Pictou Landing, and I'm talking about these because they're already in the public domain. They've been referred to tribunals, they've been referred to courts. I would not be allowed to comment on anything that is in our complaint process and which has not yet been decided on. So Beetle versus Pictou Landing is a case that was one of the first ones that we saw that invoked Jordan's principle. Marina Beetle was, well, I don't want to say an older woman, but she had custody of her grandchild who had some severe disabilities. She took care of him 24/7, and at one point in time she suffered a small stroke. She became unable to care for her child, or for her grandchild, 24/7 in the same way that she had before. She really needed some respite funding, some respite care. It was not provided, and she argued that it would have been provided had she not lived on a reserve. It would have been provided if she had lived in the city next to the reserve. So she raised that as a case before the federal court, and they agreed that she should have had access to respite care. And they relied on Jordan's principle in rendering that decision. So that's one kind of example, and it goes back several years. Sumner Pruden is a case involving, again, a child who had severe complex disabilities. He required special education supports and specific health services. He and his mom, Harriet, lived on the reserve as a First Nation in Manitoba, and she was not successful in getting the supports that her child really needed. She took this complaint to the Canadian Human Rights Commission. We weren't sure whether it was our jurisdiction or whether it was provincial jurisdiction, so we encouraged her to file in both jurisdictions. She did so. We've referred the complaint to tribunal. Part of the complaint has been settled there. The other part, in a provincial context, the Provincial Human Rights Commission has gone to an inquiry on it. And so this is one way to make sure that jurisdiction is covered. file in both circumstances or in both jurisdictions if it's unclear. Mississauga of New Credit. Okay, so this is a case involving two children. They're twins, both of whom had severe medical needs. They had complex disabilities. They required special education supports. They lived on reserve at Mississauga of New Credit First Nation. And the problem here is that the First Nation had a specific special education funding just to provide the supports for these two kids, the twins, would have exhausted the special education funding that they had available for all of the kids in the First Nation. They said there's something wrong with this. These kids, if they lived down the street in Ajax, they would have gotten support to get educated. And yet we're forced to spend all of our budget on supporting these two kids. So in this sort of situation, it wasn't the kids or their parents that filed the human rights complaint. It was the First Nation that filed the complaint on their behalf, alleging that the funding that they were getting to support special education was inadequate, and that discriminated against them, and it discriminated against the community overall as a collective. So that case has also been set before tribunal. So these are just a few examples of cases involving health situations in a First Nation context that we've seen in the federal human rights domain. So one of the questions that have been raised by Renee is when should a person contact the commission? Either the provincial or the federal commission. And I guess the short answer for us is that if somebody believes that they've been discriminated against in employment or provision of services based on a credible ground, they can contact either commission. But I really heard what Renee was saying earlier, that the extent to which you have kind of community advocates, somebody who can help you to frame the argument, somebody who can help you to gather the evidence, that's going to make it stronger when it does come to one of our commissions. That's going to make it so that you set the story up in such a way that you can achieve a remedy. So, anything to add on that?
Okay, I'll give a cynical answer. I know I'm in Alberta, but do people know who Rob Ford was? Right? Well, I used to live in Toronto, and I have a story that's called What Rob Ford Taught Me About Human Rights. And so, if I may. So, I used to live in Toronto, and I would take the subway to work, and then get off and walk, I don't know, a few blocks to my office. And that morning, I heard Rob Ford, this is obviously when he was here, before he passed away, and he was going on about, why do we need this, and why do we need this, it's a waste of taxpayers' money, somebody's got a problem, they should just call me. Right? So anyway, I'm going to work, and it's a Tuesday, and every Tuesday is garbage day along the street, Dundas Street. And they have these big bins. And every Tuesday, they're strewn all over the sidewalk, and I bang into them, right? Every Tuesday. And I was just so peeved that day, and I said to myself, I'm going to file a human rights complaint. Well, of course, I can't file a human rights complaint because I'm head of the Human Rights Tribunal, and I'm not allowed to do that. But then I thought, if I could, okay, so I filed a human rights complaint, and then, 30 days later, I would get notice from the tribunal that it was accepted, it would be sent to the respondent, the city, and they'd have 30 days to respond, right? And then we would set up a mediation, about 3 or 4 months later. And then if that didn't settle, we'd have a hearing probably, 6 or 8 months later. So that's about 50 Tuesdays I'd be waiting. Or I could call Rob Ford. So the moral of the story is, when you should call the Human Rights Commission. I think it's a valuable, it's what I said before, it's a valuable resource, but you want to also think strategically and where you want to put your limited efforts and so forth. So I'm not saying you shouldn't call, but I think you need to understand what's involved, the pros and cons. Oftentimes, you have to recognize if you're, for example, if it's a case involving disability, the other side will ask for all your medical records. You need to be strong, and this commissions will support you, but ultimately it's your complaint. And so you need to take ownership. So I would encourage people to call, get advice, but also speak to others in your community, people who may have gone through the commission before, elders or others in the community who would provide you support. Maybe there's other people in a similar situation to you. I mean, and there can be a group complaint, which can be much more forceful, and maybe the matter being brought in the press will resolve it more quickly, right? I mean, the ultimate purpose is not to win a human rights complaint. The ultimate purpose is to assert and protect your human rights.